Good morning, Sebastian. Thank you for joining me today.
Morning, Kai.
Sebastian, you are a partner at our law firm, Taylor Wessing, based in Düsseldorf, and you are specialized, among others, on advising clients on their legal compliance with the new German Supply Chain Due Diligence Act. Now, today I would like to discuss with you what this new law, which only came into force at the beginning of this year, means for German companies, but also for their direct or indirect suppliers in China. I guess that at this point, it's already common knowledge that this law requires companies of a certain size, 3,000 employees or more in this year. Beginning from next year, this will be lowered to 1,000 employees, to conduct an appropriate due diligence on their supply chain with a particular focus on possible human rights violations or environmental issues. Now, maybe you can shed some light on what this means in practice and how this due diligence can be conducted in practice.
Okay, so beside some other due diligence obligation, the German Supply Chain Act basically requires companies to perform risk analysis at their direct suppliers. So companies need to evaluate whether they have suppliers that pose a human rights or environmental risk. And to do this, first, you need to look at the abstract risk level, meaning that you need to verify whether your supplier is located in a risky country or operates in a risky business sector. And only those suppliers that pose an abstract risk need to be looked at more closely and need to be checked whether an actual risk exists. And China in this risk analysis is not treated differently than any other country. Maybe one more thing to add, indirect suppliers, they don't need to be looked at more closely, only if you have indications that human rights or environment-related violations appear to be possible at the indirect supplier.
Now, assuming that in this initial analysis, you came to the conclusion that a certain supplier in China poses an abstract risk for your supply chain, then I understand you would have to move on to a concrete analysis of that supplier. So how would that look like in practice?
That's right. So let's say you have identified a supplier located in China that you consider an abstract risk. Then as a next step, you would conduct a concrete risk analysis to check whether an actual risk exists with this supplier. Unfortunately, the legislator and the authorities do not exactly explain how this concrete risk analysis should look like. From my perspective, there are different options. So one would be you already have information on misconduct of the supplier from the past that shows you, okay, we have a concrete risk. Second would be you have software support and, for example, use a software that conducts web screenings. And in this web screenings, you find negative information online or in social media on a certain supplier. Another idea, third one, would be you send a questionnaire to the supplier and the answers given indicate that there is a problem. And if these three ways do not work out, maybe it becomes necessary to conduct on-site audits. And this audit findings show you that there is a concrete risk at the supplier. When you conducted the concrete risk analysis and you identified certain concrete risks, then as a next step, you would need to address those risks by taking adequate preventive and remedial measures, which could be, for example, to agree on contractual obligations or to perform trainings of the supplier, further audits, and so on. So it's a huge variety of potential measures to be taken under the German Supply Chain Act.
Now, I could imagine that because the main obligation of this new law is with the German company, that they may be inclined to maybe try the steps or measures where you do not have to involve the supplier in China in order to conduct your concrete analysis. From our practical experience, I can say that there are a lot of public sources that you can use in China. For example, there's also public sources where you can find court judgments in China, which in that form does not exist in Germany. At the same time, as you suggested, in order to get sufficient information, you will most likely have to send questionnaires and or conduct on-site audits with the supplier in China. But before we continue to talk about this, maybe we can shed some light on what kind of issues specifically we need to look out for when conducting such an analysis. Now, human rights violations, for example, in the form of forced labor in the Xinjiang region, are very often discussed in Western media. At the same time, a German company may find that their supplier is not located in that specific region, but, for example, rather in the well-developed east of China. Now, what other kind of potential issues do we need to be aware of? For example, workplace safety or discrimination at the workplace?
Yeah, so when you look at China on human rights country ratings, you would find China rather considered a risky country than a non-risk country. But as you're mentioning, it would make sense to distinguish between the different rights mentioned in the German Supply Chain Act, because what we hear and see is often connected to certain violations. And I assume that not everything mentioned in the act is a problem in China. So the German Supply Chain Act mentions different human rights and certain environment-related rights, which are prohibition of child labor, prohibition of forced labor, no discrimination, freedom of association, safeguarding occupational health and safety, payment of adequate wages, and certain environment-related obligations. And these rights mentioned in the Supply Chain Act refer to international conventions. For example, when you look at the International Labour Organization core conventions, most of them have been adopted by China. And I guess maybe you can elaborate a bit more on that. There are also Chinese national laws addressing the rights I just mentioned from the Supply Chain Act. And of course, I guess, as you distinguish between the regions, there are also differences in enforcement of these national laws.
Yes, absolutely. To give you a practical example, there are laws and regulations in China that provide for participation of employees in the management of the company. For example, requesting that beginning from a certain size of the company, a labor union should be set up. But then again, in practice, you may find that either this labor union has not been established so far, or that it's not participating in the company's management as it would be provided for in these laws and regulations. But maybe because we already mentioned a few times that you may have to get in direct touch with the direct supplier and that you may have to involve the direct supplier in order to get the results or fulfill the obligations that you have to. At the beginning, I understand in the first year of the German due diligence, German Supply Chain Due Diligence Act, it addresses companies with more than 3,000 employees. This will then be lowered to 1,000 employees beginning from next year, which will then already address a lot more companies. But do you see a tendency that not only the direct addressees of this law, but also indirect addressees, for example, the suppliers of these companies, will also more and more be involved, or will even voluntarily participate in these kind of due diligence obligations because they want to be more competitive and attractive on the market?
Yes, so what we see in the market is that the demands of huge German customers, they grow. So they ask more and more questions to their suppliers, also to suppliers that do not fall under the German Supply Chain Act. So even if you are a mid-sized company, a small company, you need to answer all these questions. We can see that in particular in the automotive industry, where you can find really long questionnaires with detailed questions on your responsibilities with respect to sustainability or ESG topics, with respect to the risk analysis you perform, with respect to measures you take, or complaints procedures you established. The importance of this topic is also enormous for companies that do not directly fall under the Act, and this continues along the supply chain.
Now, if you're directly addressed by this new German Supply Chain Due Diligence Act, what kind of measures can you take in order to ensure that you will at any time be in the position to conduct an appropriate due diligence on your supply chain? For example, if you enter into a new commercial agreement with a supplier in China or outside of China, can you add certain contractual clauses to this end?
Right, so contractual clauses are basically one measure you would need to take. So let's say you have a supplier located in China, you consider this supplier a risk supplier or high risk supplier, then one of the measures you would need to take is to agree on contractual obligations, meaning that you would have contractual clauses such as certain termination rights if you have human rights violations, if you find out about human rights violations at the direct supplier. Also, obligations of the supplier to cooperate in case the German company wants to take certain measures, or to inform the German company on violations that happened and how they were addressed by the Chinese supplier.
Sebastian, apart from that, are there also clauses in which a German company, for example, can request that they will be allowed to take out audits on the ground? Is that also commonly seen?
This is common, and it gets more common because this is one of the obligations in the German Act. Companies need to address in their agreements, in particular, or certainly with respect to their high-risk suppliers. So contracts with these suppliers would need to include an audit right. Of course, audit rights are often not very popular at the contractual partner, because it means you would basically need to show your premises, your documents to your customer. But this, from my perspective, is something that will be seen more often in contracts.
From all the insights that you shared with me today, it sounds like this new law creates a lot of work, both for the German company that is directly addressed by this law, but also for its direct and maybe even indirect suppliers in China or outside of China. Now, from your practical experience, what are the main challenges that either the German company or their suppliers are facing, and what kind of advice can you give to them?
So the German Supply Chain Act forces companies to scrutinize their Chinese suppliers more closely. And of course, this could strain the relationship between contractual partners. I think Chinese suppliers that are cooperative and proactive will be valued even more in the future as contractual partners for German companies, because they can be considered particularly trustworthy in an environment that is considered to be rather risky.
Sebastian, and thank you for joining me today, and especially for sharing your valuable insights with us today.
Thanks a lot, Kai.